The federal court has just handed down reasons for Djokovic, but I thought that I'd put together a very short explainer about one part of the decision, a thing that we call privative or ouster clauses. Welcome back. Happy New Year. Let's start at the end. You might reasonably have the intuition that if a government official or minister makes a decision, you should be able to go to court to have that decision reviewed. Perhaps you intuit this as like getting a second opinion. Or maybe you have intuitions that judges are better suited to making these decisions than ministers. If you hold these sorts of intuition, you might have been surprised to hear rhetoric that the Minister for Immigration had made a decision to cancel Novak Djokovic's visa that was unable to be reviewed by the court. That's what we're about to talk about. Backstory. Djokovic or his team make an application for a visa, probably a subclass 408 visa, which would have required endorsement by Tennis Australia. Now, visa law is complex and hard. Make sure whoever is giving you politicized information about the visa process actually knows what they're talking about. For reasons that we won't get into, Djokovic was informed that his visa would be cancelled. He is told that he'll have a certain amount of time to respond to the intention to cancel. 45 minutes prior to that time expiring, the delegate cancelled Djokovic's visa. Everybody goes off to the federal court where the Commonwealth says, okay, we should have given him that extra 45 minutes. So we'll concede that the cancellation was faulty, but we're contemplating cancelling his visa using a different power. By consent, the court makes an order quashing the decision to cancel the visa. So the court didn't make any findings. There was no reason given for the orders. The first decision is quashed, but subsequently, the Minister for Immigration used a different power to make a new decision to cancel the visa. Apparently, Section 133C of the Migration Act, which is long and complex and not really worth explaining. What is worth noting, and something that I'll explain in this video, is that Section 133C includes a privative clause, also known as an ouster clause, that says the rules of natural justice do not apply to a decision under this section. Spicy. This will be a good video. To understand what's going on here, we need to think about how judicial review works. Now, the orthodox, conservative, traditional view in Australia is that there are two kinds of review of administrative action. There's merits review and there's judicial review. Merits review thinks only in terms of the content of an administrative decision, while judicial review thinks in terms of the legality of the decision. We need an easier example to deal with. Ahsoka Tano here is the president of Space. Everything is going well, except there are a lot of problems involving criminal activities and violence in cantinas. Jar Jar Binks stands up in Parliament and says, Misa proposed that we have a new licensing system in space. If you want to run a cantina, you need a license, and you need to satisfy President Ahsoka Tano that you are a fit and proper person. Lots of people put in their applications, and Ahsoka makes a decision about whether or not the person is fit and proper. That decision, whether or not they are fit and proper, is an administrative decision. Here is Bib Fortuna. His application was rejected as Ahsoka didn't think he was a fit and proper person. He self-represents, goes to court to challenge the decision, but the court says, "Look, go away. We do not do merits review. If you want judicial review, which we do, you need to identify where there was a legal mistake. Did Ahsoka err legally, or do you just not like the decision?" One day, Dr. Cornelius Evazan decides to apply for a license to run a cantina. Ahsoka doesn't even wait for the thinking music and says that he fails the fit and proper person test. He is aggrieved, and he seeks legal advice. First, he goes to She-Hulk, but she says that she specialises in freedom of speech issues, and that Evazan should instead speak to her friend who specialises in public law, Elphaba. Not all lawyers specialise in every area of law. Elphaba looks at the case and presents a different argument to the court. Yes, Evazan doesn't agree with the decision that was made, but he's not going to seek merits review. Instead, he's going to seek judicial review because the way that the decision was made meant that the decision was infected with error. Evazan wasn't given an opportunity to respond to evidence that was detrimental to his case. He feels that Ahsoka was biased in her reasoning when making the decision, and, in fact, the decision was irrational. Ahsoka responds that she's not obliged in the text of the Act to consider any of these things. This is a discretionary power for her to determine if a person is fit and proper. Evazan is looking for a backdoor into reviewing the merits of the decision by arguing that there are judicial review grounds available. But this is artificial. This is a discretionary power, and this is non-justiciable. Further, let's be really serious here, Dr. Evazan has the death sentence on 12 systems. He obviously does not satisfy the fit and proper person test. And the court sits and thinks about it and says, well, Parliament expects you to make decisions properly and lawfully. As such, the court can review the process by which you made the decision, including whether or not you afforded fairness to the applicant when you used your discretionary power. I therefore quash the decision that you made, stating that he was not a fit and proper person, and you need to go and remake the decision according to law. Now, that is a very simplified account, but it gives you the flavour of a real problem. There is a question about what decisions the court can review, and although we talk about merits review and judicial review, they might not be as clear-cut as we might think. Lots of legal history and lots of complex case law. But what if you feel like this decision really should have been a discretionary matter for Ahsoka Tano properly? Well, back in Parliament, Jar Jar really hates this decision. And he's like, excuse me, but Parliament really did intend for this to be a discretionary power exercised by the democratically elected official and not something that could be endlessly reviewed by courts. Let's amend the law to say the following. A decision that a person is not a fit and proper person shall not be challenged, appealed against, quashed or called into question, or be subject to prohibition, mandamus or injunction in any court, on any account, whatever. And you might think, Mark, you've just gone way too far with these Star Wars themed scenarios. There's no possible way that the Australian Commonwealth Parliament would ever pass a provision like this. Well, Clearly, you've never read the High Court decision of Aaron Hickman, ex parte Fox and Clinton. And in that case, there was a use of a power that was conferred for a specific kind of dispute. The authority used the power for a dispute that was not clearly within the scope of the legislation. However, the power was conferred using a privative clause identical to the one that we just saw put forward by Jar Jar. In that case, the High Court said, look, you can have all the privative clauses that you want, but the court still gets to check that the power purported to be used is validly given. Back to our easier example, let's say Greedo here asks Ahsoka for permission to take over ownership of a casino in Canto Bight. She's like, you don't satisfy the fit and proper person test, and Greedo gets advice from Elphaba, and they all go off to court with Elphaba arguing that Ahsoka's used the wrong power. The Cantina license power isn't the casino license power, and so Greedo doesn't need to satisfy the fit and proper person test. Ahsoka says, hey, there's this privative clause here that prevents my decision from being challenged. And the court says, no. That privative clause only works if you're using the legislation correctly. Greedo is right, and this was not a lawful decision. So let's be clear. The privative clause acts like a shield for lawful decisions. You can't use a privative clause to protect an unlawful decision, but if you've made a lawful decision, that decision can't be reviewed by the court. In the Djokovic case, the minister used a power you cannot challenge the decision for natural justice reasons. It's complex and messy how it all works, but in a nutshell, for Djokovic to have succeeded, he would have needed to demonstrate that there was a legal reason why the decision was defective that did not go to natural justice reasons. Final step. What do you think about these clauses? Reasonable people disagree. Now, I'm a coward, and I think that I like them in some situations and I dislike them in others. I'm not sure how I feel about Section 133C. I'm not an expert in the Djokovic case. It was far too complex for me to understand in entirety, but one thing that I suspected was that Section 113C power was really being used to sandbag a decision that should have been made somewhere else in the Act. And that makes me a little bit uncomfortable. The power was really designed to deal with threats to the Australian community, and I'm not convinced that a tennis player really posed sufficient threat to warrant the minister's personal use of these powers. So that's it for this one. Argue with me on Twitter at Legal Reckoning. I keep being told to remember to tell people to like and subscribe, so like and subscribe for good content. I'm in the process of building an auto cue so I'll be able to look directly at the camera more. Until next time, bye bye.